One drink could cost you everything. Here's what happens. A DUI in Florida is not just a traffic ticket. It can destroy your career, your finances, and your freedom. Whether it is your first offense or your third, Florida law is strict and the consequences are real. Stay until the end. This could save your life. What are the effects of a DUI conviction in Florida? Under Florida Statute 316.193, you can be charged with a DUI if you are driving or in actual physical control of a vehicle while your blood alcohol level is 0.08 or higher, or while impaired by alcohol, chemical substances, or controlled substances. Florida does not require you to be actively driving. Simply sitting in a parked car with the keys in your hand can be enough for an arrest. The traffic stop and field sobriety tests. Everything begins with a traffic stop. An officer needs reasonable suspicion to pull you over, something like swerving, running a red light, or a broken tail light. Once stopped, if the officer suspects impairment, they will ask you to perform field sobriety tests. These include the walk and turn test, the one-leg stand, and the horizontal gaze nystagmus test. You are not legally required to perform these tests in Florida, but refusing them can still be used against you in court. Breathalyzer and implied consent. Florida's implied consent law under Statute 316.1932 means that by simply holding a Florida driver's license, you have already agreed to submit to a breathalyzer or chemical test if lawfully arrested. Refusing the test is your right, but it comes with automatic consequences. A first refusal results in a 1-year license suspension. A second refusal is a misdemeanor and triggers an 18-month suspension. Many people believe refusing helps them. Sometimes it does, sometimes it hurts. This is exactly why you need an attorney immediately. The arrest and booking process. If the officer determines you are impaired, you will be placed under arrest, handcuffed, and transported to the county jail. In Florida, you will typically be held until you are sober enough to be released, which is usually 8 hours. You will be fingerprinted, photographed, and processed. Your vehicle may be towed and impounded. At this point, your Florida driver's license is taken, and you are issued a temporary driving permit that is valid for only 10 days. The critical 10-day window. This is one of the most important things in this entire video. After a DUI arrest in Florida, you have only 10 days to request a formal review hearing with the Florida Department of Highway Safety and Motor Vehicles. If you do nothing, your license is automatically suspended after those 10 days. An attorney can request this hearing and appear on your behalf. At the hearing, your attorney will question the officer or officers involved in your DUI arrest. This hearing provides the first opportunity to challenge the legality of the traffic stop and probable cause for the DUI arrest. If successful, the administrative suspension is avoided altogether and your case proceeds only through the criminal case in court. If unsuccessful, you still will likely be eligible to obtain a hardship license so you can still drive to work, school, or medical appointments while your case moves through the courts. First offense DUI penalties in Florida. For a first offense DUI in Florida with no aggravating factors, the penalties under Statute 316.193 include a fine between $500 and $1,000, up to 6 months in jail though most first offenders do not serve jail time, up to 1 year of probation, a minimum 6-month license revocation, 50 hours of community service, completion of a DUI school program, and vehicle impoundment for 10 days. If your BAC was 0.15 or higher, or if a minor was in the vehicle, these penalties increase significantly. The fine jumps to between $1,000 and $2,000 and jail time can extend to 9 months. Second offense DUI penalties. A second DUI conviction in Florida brings harsher consequences. The fine ranges from $1,000 to $2,000. Jail time can reach 9 months. And if the second offense occurs within 5 years of the first, there is a mandatory minimum of 10 days in jail. Your license will be revoked for a minimum of 5 years if the second offense is within 5 years of the first. An ignition interlock device will be required on your vehicle for at least 1 year. Third and felony DUI. A third DUI within 10 years of a prior conviction becomes a third-degree felony in Florida. This means up to 5 years in state prison, fines up to $5,000, and a mandatory minimum of 30 days in jail. A fourth DUI at any point in your life is always a felony regardless of when the prior offenses occurred. A DUI resulting in serious bodily injury is a third-degree felony. A DUI manslaughter charge is a second-degree felony carrying up to 15 years in prison, and if you left the scene, it becomes a first-degree felony with up to 30 years. The hidden consequences nobody talks about. Beyond the legal penalties, a DUI conviction in Florida creates long-term consequences that can follow you for decades. Your car insurance rates will increase dramatically, often doubling or tripling. Many employers conduct background checks, and a DUI conviction can cost you a job offer or a professional license. If you hold a commercial driver's license, a DUI means a 1-year disqualification for a first offense and lifetime disqualification for a second. For non-citizens, a DUI conviction can trigger immigration consequences including deportation or denial of naturalization, DUI diversion and expungement. Some Florida counties offer first-time DUI diversion programs. In Miami-Dade, Broward, and other jurisdictions, qualifying first offenders may be able to have their charges reduced or dismissed by completing a supervised program. If successful, you may be eligible to have the arrest sealed or expunged from your record. Not everyone qualifies, and the rules vary by county, which is why legal representation matters from the very first day. What you should do immediately after a DUI arrest. Number 1. Stay calm and do not make statements to law enforcement without an attorney present. Number 2. Remember that 10-day deadline and contact an attorney the same day if possible. Number 3. Write down everything you remember about the stop, the officer's questions, what tests you were asked to perform, and what you said. Details fade quickly and your memory is evidence. Number 4. Do not post anything about your arrest on social media. Number 5. Contact a Florida DUI defense attorney who knows the local courts, prosecutors, and judges in your county. Can a DUI be beaten in Florida? Yes. DUI cases are not automatic convictions. An experienced attorney can challenge the legality of the traffic stop, the reliability of the breathalyzer machine, the administration of field sobriety tests, and the officer's observations. Breathalyzer machines must be properly maintained and calibrated. Officers must follow strict procedures. If any part of the arrest was handled incorrectly, your attorney may be able to get evidence suppressed or charges reduced. A DUI in Florida is serious, but it is not the end of the road. What you do in the first 24 to 48 hours after an arrest can make an enormous difference in your outcome. The worst thing you can do is wait, assume it will work itself out, or try to handle it alone. If you or someone you know is facing a DUI charge in Florida, do not wait. Visit yendzlaw.com right now to speak with a Florida attorney who will fight for your rights. Whether you are in Miami, Orlando, Tampa, or anywhere in Florida or Nevada, the team at Y&Z Law is ready to help you. The link is in the description below. One call can change everything. Subscribe for more real legal guidance because knowing your rights starts here.